Okay, so thanks everyone for joining us today for our latest webinar. We're going to be covering today the issue of bullying in the workplace. And if you've joined us previously, you'll know that we like to keep these sessions as interactive as we can. So feel free, please, to just jump in and ask any questions that you like. Stop us in our tracks and ask us if there's anything you want to talk about. Um, or there'll be time at the end for questions on the topic that we're covering or any other questions you might have. Um, just if you are asking any questions or bringing any information to the table, just be mindful that we are recording. So only share what you're comfortable with sharing. We only share the recording then with our clients and people that have asked that we work with. But so it doesn't go on social media or anything like that. But just be mindful about the recording if you do bring anything to the discussion. And without further ado, I'll just jump straight into our topic. As I said, today we will be covering issues to do with bullying in the workplace. Now, if anyone's had their eye on the news over the last few weeks, the issue of bullying in the workplace has really been in the headlines, particularly in light of the report into Dominic Raab, the Deputy Prime Minister, or the former Deputy Prime Minister, conduct at work, and the finding in a report that some of his behaviour didn't, in fact, amount to bullying. So we thought it would be a good opportunity to cover that issue. It's something that we'll all have to deal with in our HR roles from time to time, grievances, complaints, things like that. So, following the report into Dominic Raab and his behaviour, as I say, there's been much discussion in the media about what sort of conduct is appropriate at work, what style of management really does get the best out of our employees, and how employers should or can react to allegations of bullying. And this really throws open the debate of where um, robust management or a hard taskmaster, and where does that blur into becoming an act of bullying? So where one person's hard taskmaster is another person's bullying tyrant, as they might say. Um, Now, in 2021, which I think are the most recent stats we've got on the employment tribunal cases, we did see a 44% increase in claims to the ET which mentioned bullying. So 44% increase is pretty huge. Um, so what do we need to take as employers from this recent highlighting of bullying issues in the workplace? Well, in answering that question today, we're going to try and cover a few things, but in particular, we're going to cover the effects of bullying, so the impact that can have on the business and then on your employees, on the potential legal risks. So we'll try and fit those allegations of bullying, those incidents of bullying, into a legal framework so we can see where our risks lie. And also, we're going to have a bit of a discussion about how to manage and respond to allegations of bullying within your organisation. Um, so that's what we're going to be covering. And I'm just going to pass you over now to Julie, who's going to take us through the detail of how to identify or what exactly is bullying in this context.
Yeah, thanks, Gareth. So before delving into the points that Gareth mentioned and the kind of finer detail of the issue, we thought it would be useful to describe bullying more fully, as much as you possibly can, obviously. So the first thing to note is there's no legal definition of bullying per se. So it can be described, obviously, as unwanted behaviour from a person or even a group of people that's either offensive, intimidating, malicious, or insulting, or an abuse or misuse of power that again would undermine, humiliate, or cause physical or emotional harm to the person that is the subject of the bullying. So bullying can be a regular pattern of behaviour. You know, you can have a campaign, systematic campaign against someone, or it can even be a one-off incident if it's serious enough. It can happen face to face in the workplace, but it can also happen on social media or in emails or calls. And it can happen at work or in other work-related situations, for instance, away days, training days, or work social events. And it's not always obvious or noticed by others. And that's why sometimes you will find in grievances that employees have to list lots of kind of small things that would be imperceptible to other people, but they know that it's being done to them to kind of tighten the screw, so to speak. Examples of bullying at work could include spreading malicious rumours about someone. I've personally seen that in my career, that an employee raised a grievance about the fact that other people were talking about her relationship and was she having, an affair with someone else, things like that. She said it was all completely false, but it was just constant and made her obviously feel really quite horrible. Consistently putting someone down in meetings, deliberately giving someone a heavier workload than everyone else, excluding someone from team social events or meetings, someone who consistently undermines their manager's authority. So that's upwards bullying. It's not always from a person, more senior down the way. And obviously putting humiliating, offensive or threatening comments or photos on social media. I think the difficulty in defining what bullying is has actually come out in the kind of public debate about the Dominic Raab furore, really. And one of the key issues, I would say, is its inherently subjective nature, obviously. So as an employer, you're going to have to listen to the employee who's complaining about it and really make that decision on a case-by-case basis. So in a report into the complaints against Raab, Adam Tolley, who was the barrister who was looking at the issue, said that he heard a good deal of evidence about Mr. Raab's use of physical gestures in communication, one where he extended his hand directly towards another person's face with a view to make them stop talking. We've all seen the talk to the hand. So that he felt wasn't bullying. And another example was that he had loudly banged on the table to make a point. So Tolley had said he was not convinced that Raab had used physical gestures in a threatening way, although those unused to this style of communication might well have found it disconcerting. What he did find to be bullying, again, and I think this shows to the subjective and subtle nature of bullying potentially, was that in a conversation with someone that he was annoyed with, one of his underlings, he referred to the Civil Service Code. And that was deemed to be a threat because essentially what Raab was doing was threatening the job security of the employee by holding over them, that he might make a complaint to the kind of ombudsman, the civil service, about a breach of Civil Service Code. So I think that just is an example of how bullying can take many forms and has to be viewed in context, taking into account the nature of the working relationship and the impact of the behaviour on the victim. I remember many years ago as a trainee, this story was passed down in a law firm about a partner who had quite a reputation, had gone to look for a trainee and they hadn't been at their desks, so he'd stabbed a letter opener, that shows you how long ago it was, into the back of their chair with a note that said, "See me." So some poor trainee came back with her cheese sandwich. It's like a dagger in their chair. So, we're laughing, but obviously I think overt forms of bullying like that are much less common, and now I think in this day and age it's much more subtle, but ultimately it can have quite a detrimental impact on the person suffering from it, and that's what Gareth's going to kind of focus in on now, the effects of bullying in the workplace.
Thanks, Julie, and thanks for triggering some of my trainee days back in Manchester. Thanks for that. I'll be fine. Be fine. Yeah, so the effects of bullying in the workplace, there's obviously quite a few ways that incidents of bullying can impact on the workplace. And where it does take place, it can often have a very serious and detrimental impact. Um, Clearly, that will be on the individual concerned, but it can obviously also have a serious impact on the workplace as a whole, on the reputation of the employer, potentially as a good place to work. So it can have many different impacts. So we just thought we'd have a breakdown the different ways in which that could impact, just so we can have a think about the importance of dealing with these kind of issues should we come across them. Some of the most obvious ways in which bullying can have an impact is the mental impact on individuals and people who experienced it. Now, people who have been bullied in the workplace can often then, as a knock-on, experience a wide range of problems. Um, that can include quite serious issues such as PTSD, post-traumatic stress disorder. And that might sound strange to some people, but actually, if you think about how closely people identify with their work and where they work and what they do, to have that part of their life tainted by or impacted by a bully, it can really, you know, can really negatively impact on them and lead to quite serious mental health disorders such as that. Certainly, in my experience, I've seen that in many cases that I've dealt with. Never underestimate that kind of impact. Prolonged bullying obviously can also cause things like panic attacks, depression, stress, and the related um, symptoms of things like that, like poor concentration, insecurity, compromised memory. Victims may change in their outlook at work and their impact and their performance at work as a result of being a victim of things like bullying. So they may become irritable, obsessive, hypervigilant, overly sensitive, paranoid, that kind of thing. And they may experience mood swings, indecision, loss of their usual good humor or positive outlook. And there may be other kind of physical um, signs that people can see. Drinking more, not sleeping as well, things like that. So it's impossible to underestimate really how the mental impact of things like bullying can be. And these are often the things that as an employer you may have to tackle or try to work your way through. When someone brings a complaint about being bullied, yes, you might be able to resolve and even put a stop to the bullying, but how do you help an employee through these kind of things? And again, moving on to more physical impacts, similar sort of thing, really, similar sort of approach that may be needed by the employer. Um, but obviously, you can find people when they are suffering from things like stress and fatigue and things like that. It can also increase, um, have an impact on their immune system. They get more periods of illness, more periods of sickness absence, high blood pressure, migraines, pains, all sorts of things like that can happen. And again, I've seen all of these kind of impacts happen in cases that I've dealt with where uh, there's been victims of bullying. Um, in terms of impact on productivity as well, perhaps, on a more um, commercial level. So if we move away from the individuals and the impact on them, we can also see that workplace um, bullying can have an effect on anyone that experiences it, anyone that witnesses it, and it can impact on productivity levels. So victims may spend much of their time trying to get support and defend themselves and get a resolution to it rather than concentrating on working. Other people may get drawn into it as well. Those who witness it um, may feel that it's not an environment that they want to work in, even if they're not the victims themselves. They look and see how the atmosphere is changing, the culture's changing. They don't want to be part of it. They're not happy with how it's dealt with. So you can lose good people in that way. Greater absenteeism, staff turnover, more accidents, lower quality of work, lower quality of customer service, and higher costs where people miss time, miss deadlines, need to rely on things like employee assistance programs, all of this stemming from decreased motivation, morale, that kind of thing. So we'll have all experienced cases. I certainly have where these things have come to bear on the workplace, and it just says that we need to take this kind of thing very, very seriously. Now, if we bring that over into the context of the legal risks that it can present, it can be very serious in that respect as well. I'm just going to pass back to Julie, who's going to take us through that side of things as well.
Yeah, thanks, Gareth. So obviously, unchecked bullying can result in potential legal risk for the employer. And the two key ones are constructive dismissal and discrimination. So, to take constructive dismissal first, one of the key components in a claim of constructive dismissal, and I'll remind you that's the one where the employee's position is that they were forced to resign because of treatment they have been dealing with at work, that because of the actions or inactions of the employer. So one of the key components is that there was a fundamental breach by the employer of the employment contract. And in bullying cases, the term that's most often said to be breached is that of the implied term of trust and confidence. So, a range of unpleasant behaviours may amount to a breach of that term. In the case of Protopa, sorry, there we go. An employee who'd been absent from work for a short time because of toothache was rebuked in such an over-the-top manner that it was humiliating, intimidating, and degrading. And this was held to be a breach of the implied term of trust and confidence. And that shows you that a one-off action can sometimes be serious enough to cause that breach and to allow the employee to be successful in the claim. In addition, over the years, case law has established that the fact that an employee receives very substantial remuneration does not buy their employer the right to threaten the employee with instant dismissal or use obscene language and insults or bullying behaviour. There was a string of cases involving city bankers, and I think one of the arguments was essentially, well, they get paid a fortune, so they should just put up with it. And the law says no, that's not acceptable. And nor does the alleged nature of a particular industry justify lower standards of behaviour towards employees. So there had been, in some cases, an idea that on the factory floor, which is perhaps a rougher, tougher environment, that employees should have to put up with certain behaviour that would perhaps be considered bullying or unacceptable elsewhere. And just with societal and cultural changes, again, that argument really has faded away, and that's not really tolerated anymore either. One of the key features of such claims is the reaction of the employer. So once bullying allegations have been brought to the employer's attention, the employer can kind of make or break a case. So taking such complaints seriously, obviously, considering disciplinary action where appropriate for the bully, if that's found to be the case, having a thorough and robust grievance procedure that really does allow an employee to feel heard and for relevant action to be taken, and also the use of mediation in certain cases are all measures which can be used by an employer to minimise the risk of such a claim. So many times I have certainly seen in my career that the employee has raised a grievance, and you've seen a moment where the employer could really have sorted it out. And quite often there's a failure to do that because of, I don't know, political sensitivities, or simply just dismissing an employee's concerns, and all falls apart after that. And it doesn't mean you have to always uphold the fact that there has been bullying, but to address it in some way and certainly allow a forum and to show the employee that it's been taken seriously is an absolute must if you want to try and head it off at the pass. The other key claim that can arise from bullying behaviour is discrimination, and Gareth's going to take us through a few of those features of that.
Thanks, Julie. Yeah. Just to flag up at this point, as I go through this section, we're going to be talking about a couple of cases that have gone through the tribunal system, and just giving some examples of comments that were made and things like that. Some of them are a little bit spicy, shall we say that? So just a word of warning if I suddenly break out into some offensive language. But according to Julie's recent blog, swearing in the workplace is the norm these days. So yeah, anyway, just thought I'd put out that parental advisory notice.
You can swear at us, just don't call us names.
Okay. There are names involved in this as well. Anyway, let's just try and see how we get on. So yeah, discrimination cases, that's the other area where bullying can manifest itself into a legal claim. So unlawful discrimination will often, but actually in a strange way, not always amount to a breach of the implied term of trust and confidence. Um, when it does, it can mean that an employer is on the receiving end of two claims. So there can be a claim for constructive dismissal and discrimination at the same time. Now that has to, for this discrimination claim to come into play, it has to involve a protected characteristic. Bullying that's not on the basis of a protected characteristic is not in itself discrimination. It has to be related to a protected characteristic. But where it is, it will usually take the form of harassment. Now, harassment on the grounds of a protected characteristic is probably the example of the most insidious form of bullying that we can probably imagine. So picking on someone because of a protected characteristic, whether that's their race, their gender, their age, their disability status, their religion, whatever it might be. We can obviously think of that as probably being one of the worst forms of bullying that we can imagine. Now, in that scenario, again, like with anything, context is everything. And that's demonstrated by a case I'm going to take us through now, which is a few years ago now, but relatively recent case of Evans. Now, in that case, the Employment Appeal Tribunal upheld an original Employment Tribunal conclusion that a comment that had been made of Fat Ginger Pikey did not amount to harassment, despite the individual having links to the traveller community. Now, taking into account the context in which that comment was made, and also the relationship between the claimant and the person who made the comment. So although the comment on the surface sounds pretty offensive to most people, when the tribunal and then the EAT looked more closely at the context of that, they found that it was not harassment on grounds of a protected characteristic. Now, the facts that they relied upon in reaching that conclusion were that there was a wider office culture of jibing and teasing, especially amongst friends. So they would use quite offensive comments and remarks about each other. And that was part of the general office culture. The claimant who had complained often used quite offensive language towards others. He used the C word. He called someone else a fat paddy on a regular basis. And the claimant was himself an active participant in many inappropriate comments and behaviour in the workplace and was seemingly comfortable with the office culture and environment that he was now complaining of. So in those circumstances, the EAT reasoned that the comments were not unwanted. But one of the features of harassment is that the conduct, the behaviour is unwanted. The person on the receiving end didn't want to be on the receiving end of it. Here, the EAT reasoned that it wasn't unwanted, since the claimant was such an active participant in that culture of banter. Obviously, we don't necessarily like using the word banter in an employment context because it's one of those cliched words that's used to excuse behaviour. But in this context, it really was a relevant feature that the individual was just as involved in those kind of comments and insults as anybody else. The EAT also found that the comments did not have the purpose of violating the claimant's dignity or creating an intimidating environment for him. They didn't have the effect of doing that either, and he was not offended, or he could reasonably be held to have been offended, given that he was involved in it. And the tribunal in this respect said that it would not have been reasonable for the claimant to have considered his dignity to have been violated, or for the environment to be hostile, given the particular circumstances and all of the context and material facts that we just discussed. He couldn't realistically say that he was the victim of harassment in that context. The claimant should take note, therefore, that if they actively participate in a culture of offensive banter, they may struggle to satisfy a tribunal that they were subjected to harassment in accordance with the elements of the statutory test, which you've just touched upon there, and in respect of any comments made to them within that environment. So that's quite an interesting case. And when that came out, it really did raise a few talking points. One of the things I've certainly seen this in my career many times of the scenario where people appear to have been involved or they're involved to a certain extent, and then the banter, if we use that phrase again, goes too far or tips over a line. And then the employee might say that, okay, it appears that I was involved, but I was kind of going along to get along for a while, and then I could no longer tolerate it. Um, we all kind of imagine those scenarios where people laugh along, don't want to make an issue of it at the first time. Um, but if it continues, it turns into something else. So it's not always as black and white, but it was just an interesting example of um, the features of a harassment claim, and how that can be impacted by the context of it. We're now going to pass you back to Julie, who's going to take us through some details of how employers should best manage or respond to bullying in the workplace, bearing in mind some of the things that we've already covered.
Yeah, thanks, Gareth. So, how should employers best manage or respond to bullying in the workplace when it comes to light? So the first thing that employment lawyers always reach for and always bang on about are policies, focusing in a document on outlining standards of expected behaviour and conduct. That is a good first line of defence. So comprehensive policies governing diversity, equality, and general civility in the workplace should be made available to all members of staff at the outset of their employment, and that obviously demonstrates that the employer is attempting to, keep and ensure certain standards of behaviour in the workplace. Training policies alone aren't going to be sufficient, so they should be supplemented by relevant training, especially for managers and supervisors, underpinning expected behaviours and reminding managers about processes for performance management of staff and those governing conduct. Because all too often what we can find is that bullying behaviour can be a result of a manager who's out of their depth, and they don't actually have the appropriate tools or the appropriate support for addressing underlying problems as they see it. Such as poor performance in their team, and that can result in them feeling stressed and then kind of heavy-handed and bullying behaviour on their part, which isn't necessarily something that's natural to them, but it's someone who's acting because they're feeling out of their depth ultimately. So training can be kind of a multifaceted about explaining appropriate behaviour, but also, as I say, equipping managers with the ability to manage well. Leading by example, research has also shown that where those at the top of an organisation can lead by example, promoting a culture of appropriate and professional behaviour, the rest of the organisation follows suit. You obviously create a waterline. Behaviours at work which promote what I've heard to described as psychological security, which essentially means that you feel able to put your hand up and admit to a mistake or share a problem or a concern. Enhance performance and morale, and again it moves away from a kind of combative conflict workplace to a more collegiate and progressive cultural outlook. And one other thing that, sometimes employees can raise a grievance to outline the fact that they feel that they're the victim of bullying, but sometimes it doesn't come to light, and an employee just leaves and they don't tell anyone. And that's where an exit interview can be really useful, because the employee really has got nothing to lose at that point, and it can be a really useful and informative tool for an employer to spot problems. And that obviously can also go if there's especially high turnover in a particular team. Again, you might want to look a little bit more closely at behaviours and the culture in that team, and then respond appropriately by addressing it. If your first lines of defence haven't worked, you sometimes will have to go to actual disciplinary level for a bully and bullying behaviour, and that's something Gareth is going to expand upon.
Thanks, Julie. Yeah. So if you do get to the stage where you have to discipline an employee for potential bullying behaviour, the usual process really of dealing with a disciplinary matter should be followed. So there isn't necessarily too much different from the usual misconduct disciplinary process. However, the sensitivity of the subject matter, if we can put it like that, mean that there are a few particular issues that need to be borne in mind. So we'll just maybe have to adapt our usual approach just to take account of the sensitive nature of the allegations and how serious that allegation is. Now, in terms of conducting the initial investigation, this should be carried out as soon as is reasonably possible once the allegations have come to your attention. Now, as Julie mentioned, sometimes that may be as a result of a grievance or an employee complaining there and then about something that's happening, but it's possible that these things can come to light much later down the line, perhaps after an exit interview or something like that. Um, that doesn't necessarily preclude you from dealing with it just because it happened a while ago. If you become aware of it, then you should tackle that and deal with that as soon as reasonably possible once you've become aware of it. Um, and that will help you establish an understanding of the fact before deciding whether to push it up to a disciplinary hearing itself. So conducting that initial investigation just to understand, is there some substance here? Is there a case to answer? Um, or or am I able to get to the bottom of it at investigation stage? So as with any investigation, you need to ensure that it's carried out with an open-minded approach and avoid jumping to conclusions. So having a good investigator, someone who can behave impartially here, is who's not previously been involved with any of the people that are concerned in the matter, can be really helpful because they don't then bring their own views on individuals to pass on the investigation. Whether that goes, well, come to a conclusion that someone's guilty because I've seen them and I don't like them, or I don't like the way that the way they work. So I'm going to assume I can all too easily believe that they bullied someone, or equally vice versa. I don't trust that person. They're just throwing around malicious allegations. There's nothing to it without properly looking into it. It's really important to conduct a proper, thorough investigation there. Now, once you have completed that investigation, again, like in any scenario that involves disciplinary processes, you should determine then whether you're satisfied that the conduct or the alleged conduct is serious enough to potentially warrant some form of disciplinary sanction. Um, Now, we flag this point now because it wouldn't normally be reasonable to proceed to a disciplinary hearing. For example, if even at its highest, the misconduct alleged was just too trivial to warrant any form of disciplinary response. So if you're satisfied on investigation that it really is a very one-off trivial matter, it could be arguable there that it doesn't necessarily meet the threshold of being an arguable misconduct allegation and that needs to be considered at a disciplinary hearing. Um, Now, an investigation can, as we're probably experienced with, can be carried out without giving the employee any advanced warning or allowing them to be accompanied. And this is often the moment in the process when you're most likely to get a truthful and credible account of events, as the individuals in question have not had time to prepare or even, we might say, concoct a more sanitized or a more um, detailed or, defensive version of the truth, if we put it like that. So often the best way is to just uh, just arrange a sort of informal investigation conversation, which is fully noted and goes on the record, but just kind of catches that person um, unawares and just gets their version of events at that early stage. Now, another factor when dealing with an investigation of disciplinary matters, and this comes up quite a lot, and there are lots of different ways of dealing with this, and not always the easiest scenario when it does arise, but is when you're dealing with potentially anonymous complaints of bullying, whether that's the victim who wants to remain anonymous, or whether that's potential witnesses who are prepared to kind of corroborate some of the allegations, but only on the condition that they're kept anonymous. And where that is requested or where that's potentially relevant from your own point of view as well, that really should be considered, especially where the allegations, which might be quite common, are against someone who's more senior than the alleged victim. So they're complaining about their boss or perhaps even someone more senior than that. Um, Things like anonymity of the victim or the witnesses is going to be really important. And again, in practical terms, that's not always the easiest thing to achieve because you need to conduct a fair disciplinary process, a fair investigation, and occasionally anonymizing witnesses and not saying who's actually made the complaint can impact on someone's ability to kind of respond and defend themselves and recall conversations and put different context on those conversations. It's not always the easiest thing to manage, but it will always need to be considered, and this course of action taken if it's appropriate to do so. Then, obviously, if you've conducted that investigation, you are satisfied that the conduct is serious enough to warrant going to a disciplinary hearing, and then we'll need to proceed over to that formal disciplinary hearing stage. I'm just going to pass you back to Julie, who's going to take us through some relevant issues to consider when we get to that stage as well.
Yeah, thanks, Gareth. So, as we've said, the usual disciplinary hearing approach and format should be used. So that means the employee should be given written notification of the details of the allegations against them in advance of the meeting, and that should include, where possible, dates and times of relevant events. Essentially, I think that the overarching principle is that the more opportunity the employee has to defend themselves, so that the more detailed the case against them is, the harder it will be for that employee to challenge any decision at the end of the process. And for them themselves to allege that there has been some unfairness towards them. So the employee should be given all the evidence which will be considered at the hearing, and that will include witness statements and, as Gareth has mentioned, anonymised where necessary and where appropriate. I mean, sometimes you can agree to anonymising a statement, but everyone knows that the detail of the statement will really give away who has said it. So there's only so far you can go with that, while still balancing the rights of the person accused to understand the case against them. But I think, and this, almost goes without saying, but you'd be prepared for quite a tense meeting, because the individual accused may really be quite shocked at the fact that they're considered to be a bully, and they may be angry, they may be upset. So just be prepared, perhaps, to be able to adjourn, while a person kind of calms down or whatever. Have water, have tissues, just silly things like that. But just, you're not wanting to ruin that person's life either. You're wanting to give them a chance and a platform to discuss, their views. And
Just on that, Julie, that's a really good point, because I've rarely come across cases where, I mean, I have come across them, but it's much rarer to come across cases where someone either holds their hands up to it and knows that they've been deliberately doing it. It's usually the case that people either completely oblivious to how they've been perceived. Doesn't mean they haven't been bullying someone, but they've been oblivious to it, so it comes as a shock to them. Or I've even seen cases where people thought they were trying to be positive, or that was how they're motivated and managed, by pushing people and things like that. So, more often than not, I think that's a really good point, that you do get those tense conversations where people really feel shocked and don't really know how to defend themselves, or are really surprised that the allegations come out. So then you're dealing with a much bigger thing than you would be if it was just, you've been accused of poor timekeeping, and that's a disciplinary offence, and it's just more straight down the line. Kind of goes without saying, but it's useful just to remind ourselves of that it's not an easy conversation with anyone
Yeah,
when we're doing that.
it's much more loaded, much more
Yeah.
emotional. Absolutely. And finally, in reaching a decision after the disciplinary hearing, you obviously need to work out how to articulate an appropriate justification for that decision. Again, because of some of the points we've touched on, you have to have a really kind of robust reasoning. But equally, we have to remind ourselves that we're not the police, we're not a court. So you can simply choose to believe one person's version of events over another person's version of events, or the impact on one person. We've had cases where someone has put teams targets, in the staff room, and kind of highlighted people who are not doing so well, and they, as Gareth has said, seeing it in their mind as motivating, whereas other people see it as humiliating. And so ultimately, you know, that has happened, and it's just really the impact on the various different people that you have to decide as an employer. Well, look, it has had this negative impact, and therefore we are going to uphold that ground. And yeah, as I say, just be able to justify your decisions. And unfortunately, in the most egregious cases of bullying, where you feel it has been proven, dismissal for gross misconduct can be appropriate. So you've got the whole kind of range of sanctions available to you. But as we have mentioned, sometimes it can be useful to use things like mediation as a result, rather than something maybe as kind of hard hitting as dismissal, especially in cases where it's perhaps more of a grey area as to what has gone on. And what you will also sometimes find, just as a final kind of aside, is that the person who has been accused of bullying can occasionally raise a grievance themselves during the disciplinary process about treatment that they feel they have suffered, especially when it's their attitude and behaviour that is being attacked. The general consensus is that a disciplinary process should be postponed whilst a grievance is dealt with. But I think commercially and practically that's not always necessary or actually appropriate. And if all the issues at hand are interlinked and intertwined, then it's absolutely reasonable to look at these side by side or concurrently. And sometimes what you can find is a disciplinary hearing is also a grievance hearing, although I don't know if I would go that far. I would normally, you know, have two separate meetings, but certainly the decision can be taken at the same time, looking at both processes at once, essentially. But it's probably useful to take advice on specific circumstances, because that's obviously where it becomes quite complicated, and you need to unpick it and decide what's the best for the employer, really, whilst giving everybody their say. As you know, what's the least risky approach? And sometimes that might mean the process goes on slightly longer than you would like, but that's the process is at an end, and you don't have, you know, two appeals and a tribunal at the end of it. So it's sometimes worth to take that little bit longer. It just depends on the circumstances.
And you sometimes will get in that context that the grievance that's brought by the person that's accused of bullying, often many of the grounds of that grievance can effectively be defences to the allegation or a reaction to the allegations against
Yeah,
them, and where it might be appropriate to, you know, you are perfectly entitled to bring that issue forward, but that's best heard as as a defence to the allegation in the disciplinary, not a separate grievance, and things like that. Um, the other tricky thing, just going back to the point about outcomes of, okay, yeah, in the most serious cases, you've got gross misconduct, you've got dismissals, but in those that fall short of that, you can then be put in a tricky position as the employer of getting those two individuals to continue working together, and you may get people who flat out refuse. I'm not going back to work with, alongside, or for, if it's the manager, um, that person, given what's happened. And we haven't really got the time to go through all of those issues today because it could be a separate conversation in itself. But there are often these aftermath issues to kind of work through of, okay, well, I've dealt with the grievance, I've disciplined the individual. Um, how do I move forward now? And as Julie mentioned, mediation can be useful, whether that's informal or a more formal process. Um, but sometimes you can be in tricky scenarios of having to move people around and redeploy them in different positions, and that can be fraught with difficulties as well. Because who do you move in that context? You know, it may not always be that straightforward. So um, it can lead to these knock-on things as well that we're still dealing with after the event. But as I say, we've not got the time to go through all of that now. That would be a big conversation thinking about all those scenarios, but it's worth bearing that in mind.
yeah.
And I think that's pretty much everything we wanted to cover, I think, isn't it, Julie?
I think so, yeah. I don't know
Yeah.
if anyone's got any questions or any examples, or without it turning into a therapy session. If anyone's got anything they wanted to raise or discuss, we're happy to talk about it.
Nothing from me.
Thanks, Gary.
Okay. Well, if there are no questions, we can finish up a little bit early, like get back to your busy days. And if anything that we talked about today is relevant to anything you're dealing with, or you do want to discuss it, give us a shout offline if you want to as well.
Yeah.
Cool. Thanks, Gareth and Julie.
No problem.
Thank you. Thanks,
Thank you.
Paul.
Really helpful.
Thank
Thanks.
you so much.
Thanks,
It's been
Susan.
really helpful.
Thanks.
Thanks.
Bye.
Thanks, Natasha. Bye. Bye.
Thanks,
Bye.
everyone.
Bye-bye.
Bye, everyone. Bye.
Have a good weekend. Take care. Bye.
Same to you.
You too.
Thank
You
you.
too.
Ciao.
Bye,
Bye.
Christina. Bye. Bye, Becky. Thanks, Lisa. Gosh. Good. Another one.